Hello, good evening, good afternoon. It is 6:30. My name is Jordan Walker. I'm an attorney with Seaver Walker Paget Law Firm. We're going to go ahead and get started so I don't keep you guys here too late tonight. With that being said, we'll go ahead and share my screen and start this presentation. Again, thank you for stopping by tonight. My name is Jordan Walker. I'm an attorney with the law firm Seaver Walker Paget Law Firm. Excuse me, Seaver Walker Paget Law Firm is an eminent domain only, landowner only law firm. This is the only area of law that we practice. Our practice is dedicated, our firm is dedicated to helping landowners in your very situation, landowners that are subject to or affected by a road project that potentially can mean you're subject to eminent domain. We are not with MoDOT. We are adversarial to MoDOT. Not only do we not represent MoDOT or any other DOTs or utilities or anybody who can take land, we never have, and we've only represented landowners faced with these eminent domain acquisitions. We do this in Missouri. We do this in several states. I'm personally licensed in Missouri, in Texas, Georgia, Indiana, Illinois. And I actually went to Mizzou, so I have quite a bit of knowledge about I-70, especially driving on it, going from St. Louis and going back and forth. So I'm very familiar with this project, this road, and I'm very familiar with this project too. And what we're going to be doing today is we're going to be talking about the project. We're going to be discussing eminent domain, but largely we're going to be sharing the knowledge that we've accrued over so many years, doing this in so many states, handling so many cases. That's the name of the game today, is to educate you so that when MoDOT comes in and starts talking about making offers, you're ready, you're prepared, you know how to handle it, and you know what to expect. One question we get a lot is, why did you receive this letter? Why did I, the landowner, receive this letter? And the reason why you received this letter is because, according to information, publicly available information, your property might be affected by this project. This project is in flux. It's somewhat fluid. Plans are changing seemingly by the day. So this can always change. It's always subject to amendment and change. But according to our information, your property is in the path of this project and will be affected by it. So that's why you received it. But again, we don't work for MoDOT, and we don't have access to their information and their most recent plans. They sure are not going to provide that to us. So, information is not perfect, but we do what we can. Either way, we anticipate your property will be affected by this project. The project, I-70, Improve I-70, a ambitious project to rebuild, widen, and improve I-70 across the state. I'm sure you've heard of it already, if not through your individual parcel or just otherwise. It's a very substantial, very significant project. It is divided into 8 segments spanning the state. They're really focusing on 3 segments right now, from Blue Springs to Odessa, Warrenton to Wentzville, and Columbia to Kingdom City. There are hundreds, I think possibly even thousands of landowners that are affected by this project. Businesses, all sorts of property is going to be affected. They are expecting to complete this by 2030. That seems, talk about ambitious, that seems very ambitious. I'd be shocked if it's done by 2030. I think it's closer to the fact that they'll be starting construction closer to that than they would be finishing it. So that's their goal, though. That's what they're saying, and it doesn't hurt people. It's not harmful to be overprotective over when this is going to come, when it's going to happen. Eminent domain is a reactionary, responsive area of law. You don't initiate anything, you respond to what is provided to you. So it's good to get ahead of it, which you are doing right now, of course. So that is the project. Let's talk about what eminent domain is. Put simply, it is the power, it's the forced acquisition of your land for a public use, public purpose. Usually, or most traditionally, it's thought of as being exercised through MoDOT, the state of Missouri, federal governments, the cities, counties, any governmental entity. Building roads is really what people think of, if they think of anything, when they think of eminent domain. Ultimately, it is the ability of them to take your land, whether you like it or not. meaning it doesn't matter if you don't want this to happen. It doesn't matter if you don't think it's fair or you think that the road is stupid or that it shouldn't be built or it's a boondoggle or whatever. All those things don't matter. What matters is that if they want your land, if they need your land for this project, they are going to be able to take it. It's pretty much as simple as that. But while they can take it, they still have to pay for it. And they don't get to just pay what they think you're entitled to. They have to pay you just compensation. And just compensation means that you're entitled to whatever amount of money, whatever amount of compensation justly compensates you for your land. Traditionally, this is measured by the fair market value of your property. MoDOT, the government, has eminent domain authority. This is not something that you're going to be able to dispute. If this were another entity, utility, a co-op, something like that, you might have that argument, but you do not have it here. And that's all to say is it's very difficult to stop these acquisitions. It's very difficult to stop an eminent domain acquisition in its tracks. And even when you are successful in stopping it in its tracks, it's oftentimes the entity that's taking land can just refile their lawsuit and correct their errors and get it that way. So it's very difficult to stop these things. I will tell people that stopping, moving, changing, altering, that's usually a political, small p political process. It's lobbying your representatives and so on and so forth. But that is how you stop these takings. It's a much easier battle to minimize the acquisition, maybe limit what they're taking, and fight for more money. The battlefield is a lot more even when you're talking about fighting for more money than it would be, for example, stopping eminent domain. It's a much more even battleground. You have much more even footing, and you can definitely make some progress in that field, in that topic, much more so than in other issues like stopping the project or stopping the acquisition. So what I tell people is, if you want to stop this thing, we can talk about it. I'll probably end up talking you out of it, or I'll tell you, I don't know if we can help you out, because a lot of time, I mean, we've done it before. Don't get me wrong. We've definitely and been successful in doing it, but they are very select situations, and it's a very fact-specific analysis. So in any event, I want to talk about the land acquisition, the eminent domain process in the state of Missouri. This is the procedure that they need to file before they file any sort of eminent domain lawsuit against you. They don't need to do a survey, but I included it anyway because they are generally done. And the reason why I include the surveying is because it's the first time you'll be able to see the acquisition on the ground on your property. So the process, I started with surveying. Again, it's not a legally mandated requirement, but they do it. A survey, I tell people again, the survey is the first time you're actually going to see the acquisition on your property. And this is indicated through survey flags, markers, paint on the ground if it's concrete or asphalt. And they'll have different colored flags depending on what the acquisition area is. But that's the first thing that I tell people, is that survey is the first tangible step in the process. The next step is the appraisal. And the appraisal I tell people, is the first step that that an offer is coming. In order to acquire your property in eminent domain, they'll need to appraise the property. They will appraise it. They'll come out, they'll do their appraisal, and then they will issue an offer that is based off that appraisal. And that is the 30-day offer. So they'll come out, they'll appraise the property, and then a right-of-way agent will come out with an offer based on that appraisal, and they'll issue you the offer. I tell people at that point, that is when you should be hiring an attorney. That is when people generally hire us, is when the offers are issued, offers are on the ground. That is the case because it allows me to evaluate what they're taking. And at this point, you'll actually know what they're taking, because as part of the offer, they will put out the metes and bounds of the acquisition, how much square foot, how much acreage, do they want any easements for construction? What exactly are they taking? This is when you're first going to learn about it in depth, in the detail that you want to. So they've issued the offer. Let's say that it's not even close to what you're entitled to. And the offer is too bad. It's a bridge that cannot be, it's a gap that can't be bridged. Eventually they need to get the land, so they will file their condemnation lawsuit. Now, you'll notice I mentioned that this offer is a 30-day offer, and it's called that because After 30 days, and only after 30 days, are they allowed to file their condemnation petition. So they have to wait, 30 days before they file a condemnation petition. I should say also condemnation is synonymous with eminent domain. It's the procedure through which eminent domain is exercised. So once the lawsuit's been filed, it'll be sued. You'll be sued in the county where your property is located. You'll be served a copy of that lawsuit. And in Missouri, there is a quick take procedure built into eminent domain. And I say quick take because this is a term that's used across states to refer to a process by which the taker gets the land before final compensation is determined. So it's fairly common in states to have a quick take procedure. Missouri is no different. What'll happen is they'll file their lawsuit. The court will set an initial hearing to determine their MoDOT's right to take the property. And then additionally at that hearing or shortly thereafter, the court will appoint 3 disinterested commissioners in the county where the property is located. And those commissioners, their job, and they could be anybody, just the people in the community, the commissioner's job is to come out to your property and do kind of their own appraisal. And they'll determine preliminary just compensation. And then once they determine that, if MoDOT deposits that amount, that preliminary compensation amount with the court, they then get access to the property and they can begin work on the project. The remainder of the case in this scenario becomes overcompensation, and ultimately whatever your final compensation is. Preliminary compensation serves the function of establishing a preliminary amount that the DOT deposits, and in exchange they get access, and then the rest of the case is over what you're entitled to ultimately. So if your case is filed, you go through the quick take process, and let's say you continue to litigate and a deal just cannot be reached. Eventually it'll get to trial. You're entitled to a jury trial over the compensation you're owed to for this acquisition. And the subject of that trial will be just compensation. They'll present evidence, you'll present evidence, the jury will render a verdict. So that is beginning to end an eminent domain process. I want to state that, just because your case reaches litigation doesn't mean it's going to go to trial. Just because your case gets to the quick take doesn't mean it's going to go to trial. Some cases get to trial, some cases don't. I'll say that just on the whole, very few cases actually reach trial. And that, that's generally because cooler heads prevail. I think it's just a general rule. These cases just generally settle along with most litigation, I should say. So just because you're in court doesn't mean you're gonna have a jury trial. You're entitled to. You can have it if you'd like it, but I just want to make it. I just don't want to make it seem like if you go to court, you're going all the way to court. You're having a full case all the way to the jury trial. So each case is different. Each case gets settled at various stages of the process. Some cases get resolved before eminent domain. Some get resolved at eminent domain. Generally speaking, I tell people the difference in opinion, the larger the difference in opinion between the entities, the landowner and MoDOT, usually if there's the larger difference in opinion between those two entities, the more likely or the longer it'll take. And that's just because if you're asking for 10 million and they're asking for 1, it's going to take a while to bridge that 9. If you're asking for 20,000 and they're asking for 10, it probably won't take that long to bridge that gap. So now I want to talk about 3 keys to your case. And this is any eminent domain case. You have the property value, the remainder damage, if it's a partial taking, and then relocation expenses. So these are, everybody has to focus on the first category, property value. What is the underlying value of the property that they are taking? And of course, if they're acquiring any land, that's going to be relevant for anybody. And it's important to remember that the MoDOT's coming in and their appraisers are given instructions, and their instructions are not to go out and help the landowner. They are employees, they're third-party contractors, and they are given instructions, and those instructions are not to go out and help out the landowner. I will say that. So it's important that you make sure that, when they come in and make this offer and they start talking about property value, that they're using appropriate comps, that they are considering the highest and best use of the property. That they are not looking at old comps, or when I say comps, sales comparables, comparable sales of property located in the area of the subject. That they're not using old comps, that they're not using huge lots when it's a small lot, or small lot when it's a huge, using appropriate comps to determine the fair market value of your property. That's the first step. The second step, and this is only relevant if you have a partial taking. Most acquisitions are a partial taking. And a partial taking, as you might imagine, is an acquisition that only takes part of the property and leaves a remnant or a remainder. And remainder damage, and I have a slide on this next coming up, but remainder damage can refer to any impact that the acquisition has on the rest of the parcel. And they can be determined by a number of different ways. We'll get into them here in a little bit. But you are entitled as a matter of law to any remainder damage, that is impact that the acquisition has on the rest of the parcel. You got a 4-acre tract, they're taking 1 acre. How does that 1-acre tract acquisition affect the remaining 3? And it can affect it in any number of ways. Whatever it is, that's your remainder damage, and you are entitled to it. Oftentimes, MoDOT does not do a great job. DOTs do not do a great job of estimating this remainder damage. It's usually a big flaw in a lot of offers we see. So, and then finally, for full acquisitions, and that is a total taking, they're taking the entirety of the parcel. And for those parcels where there is a business or a residence, you are also entitled to relocation expenses. These are expenses that you're entitled to that basically amount to what does it take to get your business or your house into another house or into another business? What is it going to take for you to buy a new home? What is it going to take for you to relocate a business into a new location? And these are over and above the just compensation you're owed to for your land itself. And as you might imagine, relocation expenses can get very significant, especially for complex commercial businesses. And MoDOT, just like they don't generally do a great job appraising or making offers on remainder damage, they don't generally do a great job with the relocation either. And it's going to be incumbent on you, the landowner, to make sure each of these items is correct. And because again, MoDOT's not coming out to do you favors. You're going to have to engage in some self-help or engage in some actual help to assist you get where you need to be. And I would not rely on MoDOT to help you get there. So when they come in and make their offer and they're not offering anything for remainder damage, even though they're putting the road 5 feet from your house, it's going to be on you to make sure that you get paid for that impact on the structure, on the property's value. So remainder damage. I want to talk a little bit more about this. Really, remainder damage is a before and after calculation. And an easy example of how remainder damage can exist. Let's say before an acquisition, you got a square lot, it's a business, plenty of parking, 2 points of access, plenty of green space. It's your standard, CVS. It's your standard fast food restaurants. It's your standard lot, buildable, developable. It's got enough spaces, got everything you need to put a business on it. But after they took an access point, they took 10 parking spaces, they took green space. It's no longer a square lot. It's no longer a corner lot. It's non-compliant with local zoning and ordinances. What happens then? The difference between these two lots is your compensation for remainder damage. It was a developable lot that could host a certain number of tenants before, and in the after, maybe you can get one tenant in there, and it has definitely lost a lot of value. The difference between the two is the remainder damage, and you're entitled to that. I would say, some other examples of remainder damage. Residential, a big example for residential properties when they move the road closer to the house. That's called setback or reducing the setback. That has an impact. Zoning ordinances, that's a big one. I already touched on that. Really, I would say also for commercial lots, if it reduces the lot size to below a threshold to develop it, that's another big deal. If it's too small to develop, it turns into assemblage property. That loses value. That requires compensation as well. Again, it can be caused by a number of different issues, an infinite really, and it's also property specific. But you are ultimately entitled to it, and it is something you're going to have to voice up and argue for yourself. So now I want to talk about what to do, what not to do when you receive an offer. I don't think I saw anyone that had an offer yet on this project, which is fine. We're still early in the process, but eventually they're going to come through and start talking about making an offer. So what I tell people, these are some do's and don'ts, things you should do, things you shouldn't do. I'd tell landowners, insist that you communicate with right-of-way agents via email only. Create a record of communications between you and the DOT. So that if there's any dispute, you have a document that shows exactly what you said, shows exactly what they said, and there's no takebacks and there's no going back on what they said. If the offer is going to be extended or you're about to get it, or they've sent it to you maybe via mail, I tell people that this is the talk track that I give people. Tell the right-of-way agent, say thank you via email. Do this via email. I will review this and get back to you in a week. This is, I feel, the perfect response because, first of all, you get a copy of their offer and their appraisal via email, which makes it easy for you to then send to other entities for them to review it. You're saying you're demonstrating that you're going to be involved in the process and you're not just going to ignore it. You're not a landowner that is going to put it on the back burner and put it out of sight, out of mind, and never acknowledge it. So you're telling them that you're going to be engaged in this discussion, and then you're also giving yourself a week. And I say that because it gives yourself a week to go out and talk to attorneys, to do it, to do your due diligence, review the offer, talk to folks you trust, talk to appraisers, attorneys, people that know what they're talking about, and then respond. But also by giving yourself a week, you're not giving yourself too much time such that the right-of-way agent's going to keep bugging you. If you say, "Oh, give me 3 weeks," they're not going to give you 3 weeks. They're going to contact you a week later, and maybe then a week later, and then the next day, and then the day after that. The right-of-way agents have a knack for being ever present and contacting folks. So, but this will give you some time, it'll give you a little buffer to do what you need to do and respond to the offer if you are going to respond to the offer. In that interim, you can contact the attorney for contact an attorney for a review. Our firm, I do these reviews free. If you have an offer, it is simple as sending to me. I will look at it. I will give you my thoughts for free. I will not charge you. We do this as a matter of course. It's part of our practice. Just send it. I will look at it and I will give you my thoughts, and you can decide what you want to do. So back to this, you can contact me and I can give you my thoughts, and then you can decide what you want to do. Again, avoid in-person discussions. In-person promises mean nothing here at all. All that matters is what is signed, what is printed on the paper that you're signing. Verbal promises are worthless. So it doesn't help you to engage in these discussions with right-of-way agents verbally, especially for them. If they want to issue an offer to you, then they should issue it in writing. A verbal offer means nothing, just like any other verbal promise. What not to do. Don't jump into negotiations without talking to attorneys or talking to an attorney first. This seems counterintuitive, but a lot of folks, when they get an offer, they get an offer for $15,000. They say, "Well, I want 30," and they think, "Okay, well, I'm doubling this, so it must be good." But I tell people that doubling a terrible offer just makes it bad. It doesn't necessarily make it good. So the reality is that you might not know what you're entitled to at that point when they come in and give you that offer. So you're in the dark at that point. So throwing out numbers is not going to help you, especially because right-of-way agents are one of the things they do is keep contemporaneous notes of anything the landowners say. They'll write down if you said, "I'll take 30." They'll write down whatever you say. They keep those documents, and those documents stick with you as your case proceeds up the ladder, ultimately to eminent domain. If you told the right-of-way agent you take $30,000, they're going to write that in their notebook. That is going to stick with you the rest of your case. The MoDOT will know it. Their attorney will know it. And so it doesn't matter if you hire me and I say, "Hey, you should be getting 60 or 70. MoDOT knows you take 30 because you told them you would. So it's going to make it very difficult to negotiate against yourself in that scenario. Unfortunately, that's just how it works. So I generally, if you're going to say numbers, aim high, aim really high. I generally say don't issue any counter offer, but if you absolutely need to, go really high. And at that point, they're not going to accept it. So it's almost like, what are you doing? So that's why I generally say don't jump into negotiations without talking to somebody first. Don't jump out and don't go out and get appraisals or appraising. You might need an appraisal. I tell folks I generally don't get appraising for my clients unless it's necessary. And it's generally not necessary in my view until eminent domain. Eminent domain appraisals are not cheap. They are expensive endeavors. So if you are going to get one, you need to make sure that money you're spending is A, necessary, and B, you're getting your money's worth. Not all appraisers are the same. The guy or gal that did your mortgage appraisal is unlikely to be qualified to do an eminent domain appraisal. They are very specific types of appraisals only select appraisers can do. So keep that in mind. If you're going to spend that type of money, you want to make sure that you're getting somebody knows how to appraise, knows how to testify, and is getting your money's worth. Because at that point, it's an investment. And then beyond that, not all of my cases require appraising. A lot of cases I can get done on my client's behalf without going out and spending that money on an appraisal. But if you go out and do it, then that money's spent. So before you're going to spend that type of money, you should definitely make sure it's worth it. Talk to an attorney. Make sure that investment is the right one. Don't meet in person. We already talked about that. Don't take right-of-way agents promises at face value. I mean, this goes back to who's paying who. Just remember who is paying them and whose interests they're representing. And then finally, don't make a rush decision, but also don't ignore it altogether. It's kind of two sides of the same coin. Rush decisions are usually bad ones in these scenarios. You're maybe taking too much for granted for what's being told to you. You might not be getting a good deal. I generally tell folks if you're making that quick decision, you're probably not getting a good deal. But at the same time, it's also something you don't want to sit and put on the back burner and not address. It's something that's going to require your attention so that you're prepared when they come in and make that offer to respond, to react accordingly. Okay, folks, I got a couple slides left. If you have questions, feel free to start asking them in the Q&A in the chat, and then I will address them at the end. So real quick, how can I afford an attorney? I being you. So I can only speak for our firm, of course. Our firm works on a contingency fee agreement. If you're interested in retaining our services in your eminent domain fight, we'd be happy to help you out. Our firm works on a contingency fee, like I said. And a very easy example of how we get paid is if, let's say, MoDOT offers you $10,000, you hire our firm, we get you $100,000. In that scenario, we take a third of the 90 that we add to the case, and you get the rest. So the money comes out at the end. The way it really works is that if you want to hire me, you don't need to send me money. You don't need to write a check. You don't need to get a retainer going or anything like that. It's as simple as signing a contingency fee agreement. We start work. I don't bill you. You don't get invoices. And at the very end of the case, depending on how much more we got for you, that's when our fee comes out. It comes out at the end. It allows you to hire counsel without coming out of pocket. So that's one of the reasons why we do it. Beyond that, I think that it's good for everybody because it keeps everybody in the same page, in the same boat. Contingency fee agreements put the attorney as a partner in the case. We are invested in it. Our recovery is your recovery. I mean, obviously yours is more, but it's we all have the same goals, and that is my goal is to get a big attorney fee, and my goal is also for you to get you as much money as possible because the two are correlated, obviously. So it allows some level of trust between the parties in these scenarios. It allows you to hire an attorney without coming out of pocket. If you want to do it a different way, we can absolutely talk about that. We do billable rates. We do retainers. The other more traditional attorney agreements, but most of our agreements are on contingency fee. And then finally, this is my second to last slide, and these I first want to say that these are not guarantees of success. These are examples, and these are only 3 of many examples of how wrong DOTs can be. in their offers they make to landowners. You know, these are all real examples. The first one, again, there are so many more than this, but we want to keep it nice and concise. The first one, the landowners offered $200,000. It was a total take. We got them $1.3 million. The second one was a partial taking. They were offered $15,000. We were able to get them roughly $3 million. I'm not guaranteeing that everyone's going to get $3 million dollars. That is a very unique case involving a hotel, but it was involving a large interstate as well. So, and also a very small taking, a very small acquisition that caused a huge impact and a great example of remainder damage. And then a final partial taking where we increased it from 1 to 2.5 million. And the landowner also got additional access back as part of the negotiated settlement. So again, these are not guarantees. I'm not telling you, you come to me with $15,000, I'm going to get you $3 million. What I'm telling you again is that these guys can be wrong, and they can be really wrong. And you coming in and accepting that $15,000 or doubling it to $30,000 might seem like a win in that moment, but it obviously would not be a win, as evidenced by using hindsight of what we know right now. Doubling that offer would have left you very far in the hole. And so these are just examples. It's important to not treat these lightly, and even small takings have huge impacts you might not even think of. It's incumbent on you, to do your due diligence, protect your property, and get properly paid for any impacts that the acquisition might have on that property. This is my final slide. I will open up to questions. Please, if you have them, ask them now. Moving forward, next steps, as soon as you receive an offer, you should hire an attorney. Until that point, begin getting vetting attorney options, developing a strategy of attack, a plan of how you want to approach this, your priorities, your goals, what do you want to do. But there's not a lot you can do until you receive that offer. But once you do, reach out. I'm happy to help you out. I'll say that if you have a landowner group, and we say this in every presentation, it's all about leverage. And if you have a lot of folks in the same area that are all represented by one council, that individual council has more leverage than maybe one that only has one client. And that leverage that the attorney realizes can trickle down to the individual clients. So it's not necessary. It's not required. It's not even, it's something we advocate if possible, but we understand it's not always feasible. But if you can't get a group together, I think it would definitely benefit you. And then with that, I will open up to questions. If you have an offer, please don't hesitate to send it to me. You don't need to call me to say you're going to send it. Just send it, and I'll look at it, and I'll give you a call back. I'll shoot you a text or email you, and we'll set something up. That is my email address. It's also Jordan@landownerattorneys.com. They're the same. They go to the same place. It doesn't matter which one you use. If you have questions, please don't hesitate to email me. You can text me as well. You can also fax me there. So that is the end of my presentation. Please, if you have questions, now would be the time. I haven't received any yet, but I will allow some time if there are any. We got a question. Question was, are offers just sent via regular mail? They are going to be sent via certified mail. They are. It's possible they call you and want to deliver it to you in person. What I'll say is you are gonna feel that touch when they send it. They're because they have to send it under the law. They have to demonstrate to the court that they followed the law. So they'll do the certified mail. They'll do emails. They'll stop by. They'll call. But it'll probably start off with a certified mailed offer. Other questions? You're welcome. All right. Well, I don't see any other questions, so I am going to go ahead and wrap this up. If you have questions that you think of later, please don't hesitate. Shoot me an email, shoot me a text. Happy to answer those questions you might have. Otherwise, let me know that's the end of the presentation. Let me know when those offers come in. Happy to look at it. Other than that, I hope everyone has a good night, good luck, and contact with any questions that you might have.